Good afternoon. Welcome and thank you for joining us for the final session of our virtual in-house counsel seminar titled Inside Out Employment Law LARP. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Warden Smith, and I'll be the MC for this session. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Additionally, if time allows, our speakers will take live questions from the audience at the end of the session. If you have a question at any time during this session, please type your question in the Q&A box. During this session, you'll have opportunities to answer questions via our polling software. Please note, if you attended either or both of our earlier sessions and participated in those polling questions, you do not need to opt in again. If you did not attend either of those sessions, opting in to participate is easy. Take out your mobile phone and text the message WS webinar to the number 22333. So you'll open a new text message. In the phone number portion, you'll type in 2233, and in the message portion, you'll type in WS webinar, hit send, and you should be logged on to answer all of our polling questions. So let's get started with speaker introductions. Today's speakers are Ken Gray, Justin Hill, and Devin Williams. Ken leads the firm's Labor and Employment Practice Group. His practice experience encompasses various areas of employment-related litigation. He advises clients and litigates cases involving all forms of employment discrimination, wrongful discharge, and breach of employment contracts, from small startup companies to Fortune 500 corporations. Justin focuses his practice on labor and employment matters. He works with businesses, employers, and HR professionals across the state. Additionally, Justin is a member of the firm's professional licensing group and defends licensed professionals before North Carolina's many professional and occupational licensing boards. Devin's practice focuses on a wide range of labor and employment issues, including wage and hour matters, federal contractor compliance, employment discrimination and harassment, employee discipline and termination, personnel policies, and background checks. Devin is also the firm's co-managing director. I'm going to turn the mic over to Ken and we can begin.
Good afternoon, everyone. One thing that you did not hear in any of the bios was COVID-19 experts, but they didn't provide that course in law school when we were coming through. So anyway, we've had to learn on the fly, and it's been quite an interesting 18, 19 months of constant change. So with that said, we decided that we would do the LARP, the live action role play, and Jen has already given you the information about logging on to the polling. If for some reason you have not done so, I think you'll enjoy it. If you will log on to the number 22333, and the message would be WS webinar. Today's LARP will focus on you being the general counsel of a company, and the CEO will be asking you questions. So with that, we'll get started.
You have just been hired as general counsel for ABC Inc. And the CEO wants to know the status of the OSHA vaccination or test weekly mandate. Which of the following is true? The options are, and you can go ahead and start entering these in as you get through them, but all vaccination mandates imposed by the federal government have been stayed by the Fifth Circuit Court of Appeals until further notice. SCOTUS will likely rule on the OSHA ETS prior to year-end in light of the Omicron variant. Both A and B are true. Neither A nor B are true. And we'll give you a few minutes to start putting in your responses. And then we'll get started going through which, if any of these are correct. Seems like maybe it's, well, I thought it was starting to stabilize. So Justin, why don't you go ahead and tell us a little bit about A and that response.
So it looks like we're starting to level out a little, and we still have some responses coming in, but I'll go ahead and start off by telling you that A is not the best response, and A is in fact false. Now I will admit A is an attractive response, especially with what has been going on here lately. But the reason that A is false is because all of the vaccination mandates have not been stayed by the Fifth Circuit. Instead, that was just the emergency temporary standard for employers with 100 or more employees. However, as a team, we discussed this answer being a false answer, and we had set it up to be that way and to be a little bit of a trick. And we almost got tricked ourselves. Just Monday, we actually saw a preliminary injunction come out that halted the CMS rule that applies to healthcare employees, and it halted it for 10 states at the time. And then later on in the week, that same rule ended up being halted nationwide. And we've also seen federal decisions that now have halted the rule on federal contractors for 3 states. However, if you are not in the states of Tennessee, Kentucky, and Ohio, the rule applying to federal contractors being vaccinated is still in play. But just between the time that we actually wrote this live action role play and got prepared talking about it this past weekend and the time that we were putting it on, we've seen that change vastly. So at any time, A could become the best answer, but at this time, it's not quite there.
Okay, so I will move on to B, which is that it's likely that the Supreme Court will rule that the OSHA ETS either is able to go forward or is not going to go forward before December 31. That is extremely unlikely. While it's a possibility, it does not appear that the original dates that were put out by OSHA are going to stay in place. For example, OSHA published its ETS on November 5th. The following day, Saturday, November 6th, the Fifth Circuit Court of Appeals issued a temporary stay, which would be akin to, say, a TRO. And then less than a week later, it issued, it upheld the stay, which would be akin to a preliminary injunction. And then on Tuesday of the following week, the 16th, I believe, November 16th, because it's a challenge of an ETS, the parties were able to go directly to the Court of Appeals. And because there were multiple Court of Appeals that had different cases, in fact, there were 34 lawsuits that had been filed in all but one of the circuits. The circuits went into a lottery, and the Sixth Circuit was drawn as the circuit that's going to decide the consolidated cases. And so then we moved to last Tuesday. The government asked the Sixth Circuit to lift the stay that was in place, and the Sixth Circuit issued a scheduling order, and it provides that the plaintiffs, the petitioners, must file their response to the motion to lift the stay by next Tuesday, December 7, and then the government will have 3 days until next Friday, December 10th, to file a reply. So that tells you right there that the first date put in place by the OSHA ETS, which was December 5, in which parties had to ascertain vaccination status and get a plan in place, that's not going to be a firm date, and it will get kicked out to some extent. So we're going to see what in fact happens as this thing progresses down the litigation path. So B is not likely to be a correct answer because it's not likely the Supreme Court's going to be able to get it in time enough to rule by the end of the year.
Thanks, Ken. So based on what Justin and Ken have shared with us, while A, even as of Monday morning, A looked completely incorrect. And then with Monday's decisions and Tuesday, it started to look more accurate, but as Justin explained, not accurate, not completely accurate at least. And then as Ken has with educatedly or speculated in an educated way that the Supreme Court would not be able to actually rule on the ETS prior to the end of the year. That leaves us with C not being accurate either, not being the best answer. And I will pass it off to Justin to tell us what the correct answer is.
Of course, with only D left, process of elimination says that the correct answer is in fact D. Neither A nor B are true. That's likely the right answer, but again, echoing part of what Ken said, that is assuming that the Supreme Court does not rush and kind of take up this rule on the OSHA ETS before it is expected. I think Ken mentioned that it's unlikely that they do so, but it is not quite impossible. But at this time, we don't see that happening. So that leaves D to be the correct answer.
Okay, moving on to the next scenario. ABC has a mandatory vaccination policy. Buster Williams refuses to get vaccinated. Prior to ABC implementing its policy, Buster had voiced various personal and political reasons in opposition to getting the vaccine. After the policy gets implemented, Buster requests a religious accommodation from getting the vaccine. The CEO asks you, what can we do about Buster? So which following is true? And we have 6 different options. A, ABC can immediately terminate Buster in light of his previous comments about political reasons for not getting the vaccine. B, ABC can ban Buster from the workplace and force him to work remotely, even though he cannot perform all of the essential functions of his job from home. C, ABC can force Buster to wear a mask in the workplace 100% of the time, even though he spends 99% of his day in the office with the door closed. D, all of the above are true. E, only B and C are true. F, none of the above. So what's the best answer?
All right, well, I'm gonna go ahead and start talking, but if you haven't gotten your answer in, please do so as we talk. So A, kind of break this one down like you would in a law school exam. The information tells us that we have reason to believe that Buster's, maybe he doesn't have a sincerely held religious belief, even though he says that he does, or he's requesting the religious accommodation. And so, many employers are being faced with, if they cannot provide a reasonable accommodation to someone with a sincerely held religious belief, that the option of retaining your job and getting vaccinated, or losing your job and remaining unvaccinated, may be the 2 options on the table for an employee. So there is theoretically a possibility that ABC could terminate Buster if it cannot provide a reasonable accommodation, even assuming he has a sincerely held religious belief. But his prior comments that lead, and we don't know how egregious they are or what they exactly say, other than he has voiced opposition to it. And his reasons or his comments may have not been offensive, may not rise to the level that it would somehow violate any other policy. And so not having that information, we kind of are interpreting that we believe there's reason to question whether it's sincerely held. And there are a lot of employers have a lot of questions of how do we deal with that if somebody has given us a reason to think that they're not being truthful, that they're just saying now it's a religious belief and therefore that's why I can't get it, when for 6 months they've said something different. So A could be an attractive option because that in some circumstances someone might lose their job because they are not getting vaccinated, even if they claim to have a religious exemption or accommodation request. But here, this is more of a knee-jerk reaction. And it doesn't actually talk about any kind of analysis or what we call the interactive process discussion with the employee and figuring out, analyzing whether it is a sincerely held belief, whether there is an accommodation that can be provided without undue burden. It doesn't do any of that. And it's more of a knee-jerk reaction to terminate him immediately, not because he's seeking a religious accommodation, but because of whatever he said previously. And so A, for that reason, is not the best answer in this group.
So moving on to answer B, ABC can ban Buster from the workplace and force him to work remotely, even though he cannot perform all of the essential functions of his job from home. So that one is a little tricky. And while it is an answer that you could do, it's not quite the best answer out of the choices. Now, the risk that comes with banning Buster and only, allowing him to work from home is that it could be deemed retaliatory because he has put in a religious accommodation request. He has, invoked that protection. But at the same time, the trick about this answer choice is that, you read it and you see he can't perform all of the essential functions from home. However, in this situation, it's the employer who is choosing to, send Buster to work from home, not the employee asking for the accommodation. So the employer can change, the essential functions that the employee is allowed or required to do as a part of the job. And that part does not quite trip you up as much as it seems like it would. However, that one, again, is an answer that while it could be correct, the risk of it is that it could be deemed retaliatory as well.
And the same goes for C. Just like B could be true if that's the only accommodation that is reasonable and would not be an undue hardship. Same thing goes for C. We can actually force employees to wear a mask. Now, under the ETS, it was going to say that you either got vaccinated or you had to test weekly and wear a mask when you were indoors, except when you were in a closed office and briefly while you were eating and drinking. In this situation, we're putting him in his closed office. And so it could be argued that we're trying to be retaliatory. However, given the right circumstances, let's say employees are popping into his office every 10 minutes, then that might not be retaliatory. It may be reasonable to require that he wear his mask even when he's in his office. So that one is a potential correct answer depending upon the facts.
So D, we know that A is not the case, is not a good answer. Although, like Ken said, depending on the facts, there could be a situation where you do have to terminate Buster, even though he has requested an accommodation. But because A is not the best answer, D is also not the best answer. But I'm excited for y'all to hear Justin's report on E. So Justin, take it away.
So E is an answer that could be the best answer here. Again, this one's a little tricky, similar to what Ken and I said about both B and C. They both could be true, and it depends on the situation. The company could, have Buster work from home completely and change up his work requirements. The company could force Buster to wear the mask as a part of it, but it seems like the part of B and C that are left out is that the company's not engaging in the interactive process here. I think what we would tell you in a lot of situations is to engage with the employee and kind of go through and make sure that you go down that path and the answer that you come to is the most reasonable one and you try and at least kind of work it out through a process. And that's what both B and C are missing. So this is an answer that is likely the best answer here. But again, there are some pieces of it that still need to be filled in detail-wise.
Right. So depending on the facts, Justin's response about E is correct. It could be the best answer. Also, depending upon the facts, F could be your best answer, that none of the above are true, because Devin's explained why A is not true. Justin explained where B would be deficient, and I explained where C would be deficient, B and C being potentially retaliatory. On the other hand, if the company did engage in the interactive process and these were the best alternatives, then E would be a better answer than F. So this one, we'll give credit for both E and F, and because depending on which way the facts turn out, then that would determine which of those two are true. Now, before we move on to the next scenario, we have a question in the chat regarding, and since we're getting ready to move away from the vaccine question, I'll go ahead and address this one. The question relates to vaccines and federal contractors. Are there exceptions? And what they mean is, are there exceptions to getting vaccinated? Because unlike this ETS that OSHA put out that covered employers with 100 or more employees, the OSHA rules or the government's rules, the task force is the workforce safety task force. They put out these guidelines, and there, if you're a federal contractor that meets the coverage requirements, then you don't have a choice. You must vaccinate your employees, and they don't give you the testing option on a weekly basis. However, if in fact a person does have a legitimate religious or medical reason and requests an accommodation, an employer can accommodate them and exempt them out of getting the vaccination. And weekly testing would be an option. It's not the only option, and you would not be required necessarily to mandate that they test. You would have to put other measures in place. It could be reassignment. It could be, significant PPE. It would depend upon, it would be very fact specific and depend upon the circumstances and what work site they were going to. But yes, there are exceptions for religious and medical accommodations. So now we can move on to the next scenario.
In November of 2021, which is Transgender Awareness Month, ABC hired Rita Green, a transgender female. Viewing itself as a progressive company, ABC proudly informs its employees it has hired a transgender person. Rita is offended that the company disclosed her gender identity and complains to the CEO. The CEO comes to you asking what the company should do. Which of the following responses is the best answer? We've got do nothing, as ABC is proud of its hiring. Throw a welcome breakfast hosted by the DEI committee for Rita and request that Rita speak on transgender issues. Immediately issue a statement to all employees apologizing for disclosing Rita's status. Immediately conduct employee training focused solely on anti-harassment discrimination against transgender people. ABC should do a combination of B, C, and D. Or finally, none of the above are true. And we'll give you a couple minutes or a couple seconds to get in those responses before we start going through the answers. And if you have questions, whether about things that we're discussing or others, you can submit those through the Q&A or the chat box, and we're happy to try to tackle those as we did the last question that came in. We'll also have a Q&A at the end to address questions as well.
And it looks like we're starting to tail off with the answers being entered here. So I'll go ahead and start with A. It looks like the majority got it that A is not the correct answer. While ABC may be proud of its hiring and may not feel, as if they should do something, this is a situation where they must address it. Rita has been offended by what they have done here, and ABC is going to have to correct this and attempt to make it right with Rita in some way, shape, or form. And simply doing nothing is not the answer here. I think that the thing to point out here is In Rita's case, she's not being treated how others would have been treated had they been hired. For example, had ABC hired me, Justin Hill, they would not have announced it that they've hired, a Black male, so to speak, or they've hired a heterosexual male, so to speak. So the fact that they have treated Rita differently, while they may be proud of the hiring, they have kind of gone about it the wrong way here, and it's led to her being offended.
And in regard to B, throw a welcome breakfast hosted by the DEI committee for Rita and request that she speak on transgender issues. It is pretty much the same thing that Justin just explained. I mean, it's great. We often throw welcome breakfast, but they're not typically hosted by the DEI committee. And also, the fact that Rita has already voiced opposition or indicated that she was offended because the company disclosed her gender identity would be another reason why she would not want to be spotlighted at a welcome breakfast. So B is not the best answer as well.
As far as C and issuing a statement to all employees apologizing for disclosing Rita's status, that could look like an attractive answer because it's saying, we are quite sorry and they have disclosed that to employees. And so issuing that apology publicly on Rita's behalf or kind of to Rita, but so that other employees are aware. But the problem is that you're continuing to keep her and her status in the spotlight. And she has voiced that she was offended that the company disclosed that information. And so by apologizing publicly and for disclosing her status, it's just keeping that wound open and not allowing it to heal by speaking with Rita and figuring out and apologizing to her. An apology is probably warranted here. And it's maybe just not in the nature of issuing it unless Rita asks for that, issuing it to all employees across the company.
So D here, immediately conduct employee training focused solely on anti-harassment discrimination against transgender people. This answer sounds attractive because it's pushing for training and it's pushing for people to learn and be able to understand how to handle these experiences. But the problem with that answer is similar to what Devin just said. Again, it's putting the situation in the spotlight. The fact that this training is not just a general harassment or general discrimination training, and instead it's focused on harassment and discrimination against transgender people, it emphasizes again that the company has released Rita's gender identity here. And it further exacerbates the issue of putting her gender identity out there, which is what the company did in the very beginning to offend her. And not only that, but again, this is employee training focused on it, when in this situation it was not necessarily the employees who were needing to be trained up here. This was, the company itself disclosing to the employees. So another issue with that one is that the training is not necessarily getting to the root of the problem there either.
And then we get to E, but let me real quick do a sidebar. Justin, when you mentioned the fact that they shouldn't highlight the fact that they were hiring a transgender person, and you talked about yourself, it made me think about, well, yeah, if I was being hired, I wouldn't want them to say, yes, we're hiring a studly gentleman to start working. But anyway,
They wouldn't, Ken, don't worry.
They wouldn't? Oh, okay. All right. I digress. Anyway, E is not correct because, as we mentioned, B is not correct. Really, there's no portion of the fact that there's this breakfast hosted by the DEI committee and they're asking Rita to speak on these issues that would be appropriate. Now, there's parts of C which they should apologize to Rita about this and see how they can remedy her being offended. And D, they should conduct training. In fact, I did training for an organization on Tuesday of this week, and I very much highlighted transgender issues, but that was just a portion of the training, and it was not nearly the sole focus of it. And so I would recommend that every company make sure that you are putting a focus on transgender issues, gender identity, sexual orientation issues in light of the Bostic decision last year. And I've made this statement before in some of these webinars. Had it not been for COVID, which completely sucked all the oxygen out of the room, and the social justice movement last year, the Bostic decision by the U.S. Supreme Court would have been the major employment-related topic in 2020. And it is still a major issue and is not getting nearly the amount of attention that it should. And so I would highly recommend that companies do make sure that you are providing specific training to employees as part of your annual anti-discrimination, anti-harassment efforts. And particularly your frontline folks need to understand that, people that have a different sexual orientation or identify from a gender standpoint differently than you may perceive them to be, they have just as much right to protection as everybody on this webinar. And they should be treated the same way and not made to feel uncomfortable. And so you got to make sure those entry-level people understand that everybody's to be treated fairly, and we're not going to denigrate or do things that are adverse to folks just because of sexual orientation or gender identity.
So the best answer here is F, none of the above are true. What the company should have done when Rita complained was first to apologize for her for disclosing her identity and her status if she did not want that disclosed, which clearly she did not. The company should speak with her, figure out if there's another way or other ways that they can rectify this situation with her. They could offer, kind of in to the point about the DEI committee hosting a breakfast, they could ask Rita, we don't want to put you in the spotlight if you don't want to be and highlight anything or disclose anything, but clearly we may need expertise on sensitivity around these issues, and we would encourage you, if you want to be on our DEI committee and provide your input and your advice. They could also reassure her because she may be questioning why she was hired. Was she hired because she is a transgender female? And the company should assure her that they hired her because she was the most qualified applicant for the role. And that the company, prohibits any form of discrimination or harassment. They are deeply sorry for this situation, and they will not let it happen again. And that if anything else does happen that they were not aware of, or anybody singles her out or harasses her, or anything that she perceives as that way, give her a name, somebody she can come to. Now, she's gone to the CEO, and presumably she felt comfortable doing that. And so that may be somebody she goes to along with an HR contact. But having that kind of vulnerable conversation with her to try to remedy this situation, because similar to a disability that someone may have, while her status may or may not constitute a medical condition, it could. And it could then venture into this other situation where we've disclosed very sensitive information that otherwise should have been confidential and private under the law. So having that conversation with her, being able to kind of fall on the sword and say, we are so very sorry. We messed up here. We want to make this right. How can we help make this right? And it's almost like you're going through an interactive process with her to remedy it in her eyes. And then protecting her in case there are folks who, now that they know her status, treat her differently, which you also should not tolerate that. And so that is, F is the best answer, but we also wanted to provide you some guidance on what would be the right way to handle it.
So on to our next question involving ABC. ABC has multi-stalled bathrooms designated by gender for males and females. It also has 2 lavish single-use restrooms in the executive suite. Several female employees complain about Rita using the restroom designated for females and threaten to quit if ABC does not mandate Rita use the single-use restroom. The complaining employees indicate that allowing a transgender female to use their restroom is against their religion. The CEO asks, what should ABC do? And on this one, we've got 3 answer choices. We've got ABC should immediately discipline the employees who are complaining so that Rita will not claim that the company condones employees as harassing transgender people. B, ABC should inform Rita of the complaints and grant the other employees' religious accommodation request to mandate that she use the single-use restroom in the executive suite. Or C, ABC should tell employees who are complaining that they can either stop complaining or they can quit.
So we tried to make this one challenging, and we don't give you any of the none of the above or all of the above. So we got to see what answers come out. It's like we have a pretty good race between A and C right now. Okay. Continue getting answers in if you've not done so, but we look like that a little over a quarter of the group thinks that A is the best answer. A being that ABC should immediately discipline the employees who are complaining so that Rita will not claim the company condones employees harassing transgender people. That seems like a pretty good answer. The problem here is that the employees have also, these other employees have also invoked something that may be a protection. And they've indicated that due to their religion, they would like for Rita to be moved to a different restroom. So they're asking for an accommodation. And the one thing that we know, whenever someone asks for a disability related accommodation or a religious related accommodation, the company should not immediately jump to the end of the line to the immediate answer. You must engage in the interactive process, even if the answer is a foregone conclusion. I've been in front of the EEOC, and if a company did not engage in the interactive process, even though they were not going to be made to retain that person or hire that person, the EEOC overlooked that, and the very fact they did not engage in the interactive process to determine that they could not accommodate that person resulted in an adverse finding for the company. So you must at least just have a discussion with these employees and say, Rita is entitled to be able to use the restroom of her choice. The U.S. Supreme Court has mandated that. And so, this is not a legitimate option. Now, if the company was so willing and would allow these complaining employees for them to use the single-use restroom, then that would be perfectly fine. But not, you don't make the person that is transgender go to a different restroom. You would make the people that are complaining about it go to a different restroom. So in this situation, this is not a good answer, even though we are, we definitely don't want to ever give the impression that we're condoning any type of harassment of transgender people. But we do have to engage in an interactive process before we get to the final answer. So A is not the correct answer.
B, for similar reasons, is also not the correct answer. Now, there's parts of B that we would want to incorporate into our overall handling of this situation. So as Ken noted, we've got employees who have come forward with a religious accommodation request that could be, depending on how they do it or what they do after making that request, it could venture into harassment, which we would need to discipline it just because you have a pending accommodation request, whether religious or disability related, doesn't mean that you wouldn't be able to, that you would be able to violate the harassment policy. It's not a free pass type of thing. But with B, there's certain parts of it that we're going to want to pull out. We probably do want to speak with Rita and make her aware of these concerns, not necessarily in a way that says, you know, Sally Sue is complaining about you and says she has a sincerely held religious belief that you're violating because you're using the women's bathroom. That's not what we're talking about. But you could make her aware and ask in part of the total interactive process of whether she may want to use the single-use stall in light of this information. Making her aware, though, that she is not being mandated. We cannot, as Ken said, we cannot mandate that because then that would be discriminating and arguably subjecting Rita to harassment because we're forcing her to use a bathroom because of the one that she wishes to use. Other folks are saying she can't use because of their views of her situation. So while we cannot request or mandate that she use the single-use restroom, we cannot grant the religious accommodation request in a way that mandates Rita use the single-use stall. You could have a conversation with her to see if that would make her more comfortable given the situation. But if she says, no, I want to use the restroom that I identify with, then absolutely, we need to make very clear from the get-go and throughout that conversation, yes, absolutely, and that is your right. You are entitled to that. And we will work through this, and you continue doing this, make us aware of any concerns that you may have. So while there's, again, components of B that we might want to pull out to have that conversation, and it may be a very difficult conversation with Rita in the context of all of this, she should not be given the impression in any way that we are mandating that she use a different bathroom than the one that she identifies with. And therefore, we could not grant the religious accommodation request if the request is she not use that bathroom. And so for that reason, B is not the right answer either.
And as you all can guess, and as over half of you answered, that makes C. ABC could tell the employees who are complaining that they can either stop complaining or they can quit. The best answer here. Similar to what Devin said, similar to what Ken said, A and B both have components that you can pull out, trying to make sure that you don't appear to condone, harassment is always going to be important. Trying to make sure that you have that conversation with Rita is definitely going to be important. But C kind of gives you the end result here. Of course, similar to one of the other questions that we had earlier, C leaves out the interactive process that you need to go through. And as Ken mentioned, you do have somebody who is claiming a religious accommodation. So that does make it where the company needs to engage in that interactive process and kind of go through and speak with these employees who are complaining and make sure that they're heard out. But ultimately, Rita is entitled to use the bathroom that she chose. Rita is entitled to, that under the Supreme Court's case law. And that's something that the company can't forget. They can't throw it by the wayside. They can't, they can't move around it unless it's something that when they talk with Rita, she says, yes, I think that request would make me feel more comfortable. So while the wording of it was meant to trip you up a little bit, and it does kind of pit the company against either Rita or against the employees who are complaining. The end result of what, should come of that interactive process, if there's no push or there's no give, is that these employees, their accommodation won't be granted. And they're either left with the options of you have to deal with this and stop the complaints, or you can't work here. And there aren't really many other options for those employees because there's no reasonable accommodation here. Now, again, what Ken said, you can request that they use the single-use restrooms if that would make them feel more comfortable, but it's not something that you can force onto Rita as an accommodation for their religious request.
Yeah, and one additional caveat there, in Bostic, the one area that the Supreme Court did leave for future decisions was about religious accommodation. So we think it'll be a very narrow exception if there ever is an exception, but it is an area that could still be developed. But right now, the transgender person's rights would trump the religious accommodation request. So we'll go to some Q&As. I think I've seen some questions coming in, Jen. Will you want to read those to us?
Sure, we do have a few questions. So the first one I'm going to direct towards Devin. It relates to religious accommodations. So I've read the EEOC's guidance on how to handle religious accommodations for vaccines, but it's still not clear to me to what extent we can question an employee's sincerely held religious belief. What if we have reason to believe an employee is being dishonest or that it is not a sincerely held religious belief? Do we have any recourse, or must we accept the employee's word at the time they submit the request?
Thanks, Jen. That's a really good question, and one that if you have that question, you're not alone, because we get that question a lot from folks and in situations. So, prior to COVID, the EEOC's position on this was mostly that you don't really question the sincerely held religious belief. You don't question whether it's truly sincerely held. It's kind of a given. You take it at face value. And the belief itself doesn't have to be a mainstream belief. It doesn't have to be something that you're even aware of. They don't have to have a note from their priest or pastor like you would with a disability accommodation and needing a physician's note to verify that. So there is a lot of trust kind of innately that we have to put into the process and what the employee is saying. But with COVID, COVID surrounds us and political, personal, religious, medical, health, all these issues that are surrounding us surround COVID. And folks have varying degrees of opinions on COVID and the vaccine in particular. And so it is very common that the lines between a pure religious belief against the vaccine merges with a political belief or a personal conviction or even a medical related issue. And so, COVID has shown us with some of these religious accommodations, we've gotten more in the last 3 months than we have seen in at least in my career. I've looked at more religious accommodation requests in this short span of time because of the vaccine mandates. And so the EEOC's guidance, specifically relating to COVID, is helpful. It provides a little bit more information than previously we had as it related to COVID, but it still leaves a lot open and a lot open for interpretation. And that's kind of the part of it, is that each one of these is a case-by-case analysis. And so when somebody comes to you, we've had situations where there has been information posted on social media prior to the employee making an accommodation request, religious accommodation request, that directly contradicts what they're now claiming. Or, for example, and this isn't necessarily what happened, but this is an example. If an employee is out there posting on Facebook, for example, that, I'm against the vaccine because I'm, I don't like the government telling me what to do. Okay. And it's not about my religion, but it's about big government. I don't like big government. I don't like the government, big brother watching over my shoulder, that kind of thing. If they're out there saying that and they say something so clear, like it is not about my religion, and then they come to you and they say, I've got this sincerely held religious belief that I can't put this vaccine in my body, that gives you reason to believe it may not be sincerely held. And that information is very helpful, but you still need to look at what they say in that request and what information they give. And first and foremost, look at the request before you try to attack it as incredible. Go into it with the assumption that we are going to take him or her at her word, and we're not going to try to attack the sincerely held belief part of it. But if in reading it, it's contradictory to, or there's other things, or again, you have this kind of smoking gun comment that they made that indicated they were going to be dishonest in claiming a religious accommodation when they don't have a religious belief, a sincerely held religious belief, then that may be a reason to deny the request. I will tell you though that in conversations we've had with EEOC, high-ranking EEOC officials, even in that type of situation, they are very hesitant to say, yes, that's an open shut case, you can deny that accommodation request. So they're going to go through it with a fine-tooth comb if that person were to file a charge that you discriminated against them in violation of their religious beliefs. The other thing to keep in mind is you may have seen the Pope came out and said that it's not a Catholic belief that you cannot get the vaccine. And you may have folks who are coming forward saying I'm Catholic or I am Christian or I am Jewish and giving one of the more predominantly known religions and claiming that it violates their religious beliefs. Please don't make which would be a common assumption to make, but please don't make the assumption that because a high level official or representative or someone like the Pope comes out and makes a statement as to what that religion stands for and what they believe, don't assume that that means that person who has submitted the request, they share that same belief. I remember years ago, Tom Colclough with the EEOC gave a presentation and he talked about the religion of one, that you can have a religion of one. And he used kind of this odd example that we all chuckled about at the time about, someone could come in and say, hey, my religion is I've got to wear rocks on my head all the time. And so I've got to walk around with these rocks on my head. And I know you probably think it looks odd, but that's my religion. I believe in that. And if someone sincerely holds that belief, however strange to us it may seem, or however non-mainstream it is, it still may qualify for a religious accommodation, assuming you can provide it without undue burden. So the analysis of to what extent can we challenge it, you can. You just want to be careful in doing it. You want to make sure that you've asked the right questions, the appropriate questions. You don't need a letter from their priest or pastor or pope or whomever they follow. And technically, they don't have to follow anyone else. It could be just their own belief. But if it is religious in nature, spiritual, higher power, those types of things, then you give a lot of credence to what they are saying, not what you think of that belief, So it is hard, and I will tell you, it's we've told a lot of folks, advised a lot of employers to kind of start from the standpoint that we're going to accept that your religious belief is sincerely held and that you oppose the vaccine for that reason. And then we're going to go into the interactive process analysis and figure out if there is an accommodation we can provide to you. Start from that mindset And it should be a very rare, and you may not be able to provide an accommodation. It may be an undue burden to provide an accommodation. You may ultimately deny the request because of that, but you haven't denied it because you don't believe it's sincerely held. Hope that's been helpful to the folks who had that question. Thanks, Jen.
Thank you, Devin. We still have some time, so I'll direct the next question to Justin. With remote work becoming more popular, my company began hiring employees from different states to work 100% remotely. What are some key issues that companies hiring employees out of state should expect?
So remote employees is an issue that we have seen, or at least I have in my practice, somewhat exacerbated due to COVID. And kind of early on in COVID, everybody realized that their employees could work remotely, and a lot of companies just never went back to being in the office full time. Of course, with that also came hiring employees that are not necessarily in the state that you operate in. And there are various issues that comes with. If you are of the belief that you're hiring, and your company's in North Carolina, so you can basically treat all of the employees like North Carolina employees, you would not be the only person to think that, but that's not necessarily the case. And we actually do advise a lot of companies on different updates and issues that are coming out across, all 50 states, just because there are so many differences. For example, there are all sorts of discrimination laws and protections for employees that change across the different states. Connecticut recently updated its sexual harassment training requirements, and it applies to employers who have employees in Connecticut, but as a whole, it applies to employers with only 3 employees. So those employees are counted for the whole company, but you only have to train for the Connecticut employees. There are also Crown Act, discrimination protections that have begun to be a trend now, and those essentially protect the ethnic hairstyles of employees and basically add that to the definition of race. We've also seen a lot of equal pay acts or wage disclosure acts that are meant to protect employees. And while North Carolina may not necessarily follow each one of these rules, if you have employees in states that do follow those employees need to be protected under those laws, and they will be, by law. You look at other situations like leave laws or, your vacation and PTO policy. Are you forfeiting the time upon termination? When you actually pay an employee if they've been terminated? All of these things can change as well as a part of, the wage and hour laws that are applicable in these different states. And they're all things that you have to take into account. And then one other big piece that I think I would be remiss if I didn't mention is there are state insurance programs in different states that essentially act as a family and medical leave provided by the state, but employers have to deduct from payrolls to pay into these systems. And you can be fined if you're not, paying into it and you have the employees in the right number in that state. So there are repercussions that come with not knowing these laws. But again, if somebody has a home base in North Carolina and those aren't the regular laws that you have to abide by, it's easy to miss out on a lot of them.
Thank you so much, Justin. All right, so Ken, I'm going to ask one of the final questions we've got to you to close us out for today's session. And that question is, what is your perspective on DEI programs, and what advice do you have if our company wants to implement one?
Well, first of all, I believe that every company should have a DEI program, a policy. However, I think there's a lot of training out there that is absolute garbage. Any training or policy that leads one group of people based upon skin color to feel like they are bad people or they're inferior is not a quality program. And there was recently a reverse discrimination charge in the Western District of North Carolina. It was, I think, in October, where Novant got a $10 million verdict because they were trying to implement their DEI program and were doing so in a manner which actually discriminated against people that were Caucasians and men. And so that just has come down, and I'm curious to see how that case progresses. But anyway, you should have a DEI program, but you need to implement it smartly.
Thank you, Ken. And thank you so much to you and Justin and Devin for your time today. I'm sure many of you attended our earlier sessions. Just like with those, we'll send an email following today's seminar with a link to the recording as well as a copy of the slide deck. We are still waiting on approval for CLE for this session, but as soon as it is approved, Warden Smith will submit accreditation materials for attendees seeking North Carolina CLE only. If you need out-of-state CLE, please email us at rsvp@wardensmith.com. We'll send you a certificate of attendance and the webinar materials for submission. We appreciate you taking the time to join us today. Thank you again, and that concludes our final session of our virtual in-house counsel seminar.